Welcome to Latte with a Lawyer, a podcast dedicated to bringing you the stories of some of America's most successful lawyers, figuring out what makes them tick, how they creatively solve problems, and how others aspiring to be them can follow in their footsteps.
Okay, welcome everybody. Another episode of Latte with a Lawyer. I'm your host, Jonathan Brickman, and this afternoon from California, we've got Scott Lantry with the firm of Whiting, Ross, Abel, and Campbell. Welcome to the show, Scott.
Thank you, Jonathan.
Good to have you. You're number 6 today, so you're in the lucky position of cleanup.
Yeah, and you get to go home after this, I hope.
Well, I am home, as you can see in the background. This is where I spend my days now that the world is remote. Although it looks like you're in an office there.
That's correct.
Okay, good. Well, just for the statistical reasons and to keep with the theme of the show, what's your morning beverage of choice to get started?
I'll start. I've switched to tea. I'm trying to watch the caffeine intake a little bit. I'm trying to be a little more mindful, a little bit on the self-care. So I'll have about 3, 12-ounce teas throughout the day. I'm channeling, Jean-Luc Picard from the Enterprise, Earl Grey hot.
Excellent. Good stuff. Yeah, we got a wide range of people. And again, I keep saying it, we got to keep the stats because it'd be interesting to post it in the distribution of this, but it's not all coffee drinkers. A lot of people drink water, energy drinks. People with coffee would like all kinds.
Well, I'm grateful that you don't discriminate against us non-coffee drinkers.
No. Listen, I grew up in my family actually drinking tea, and now I drink very little tea and mostly coffee because it's easy to pour it. Yep. Anyway, enough of that stuff. So, tell us about the kind of work that you do there.
So I work at, as you mentioned, the firm name.
Yeah.
Although since this is shameless self-promotion, I'll say it again: Whiting, Ross, Abel, and Campbell LLP. We're based in Walnut Creek, California, and we practice family law, predominantly in Contra Costa and Alameda counties. Although we've been known to travel further than that. So we focus on divorce, which in California we have to be fancy and we call it dissolution of marriage, but I prefer to just call it divorce, as well as parentage, formerly known as paternity, which is a divorce when you weren't married but you have children. We do a fair amount, more, I think, after COVID, of domestic violence work. And some of my colleagues enjoy working on premarital agreements. Although I personally think that's like saying I do with your fingers crossed, but that's okay. And we counsel and advise couples. I've got a couple of cases going right now, too, as a matter of fact, right now, where I represent a grandfather and grandfather's corporation who got roped into grandfather's son's divorce on a joinder theory. So as it pertains to family law, we'll do most anything.
Okay, so it's just under that umbrella.
Yes.
Yeah. Okay. No estate planning, none of that.
That's correct. Yeah.
Oh, interesting. So that's good. I like focus. Focus is always good. That becomes you build a brand around that and people know you for that.
Yeah, I think, I'm learning more and more about less and less. And pretty soon I think I'm going to know everything about nothing.
You guys are pretty funny. I talked to another attorney that had me laughing the whole time. You guys have a good sense of humor.
Well, in this line of work, you kind of have to have it,
I mean,
but thank you. I appreciate it.
As I said to him, and maybe I'll say the same thing to you. If you get tired of lawyering, you can always be a stand-up comedian.
I doubt that. I'll be heckled right off real quick, but you're very kind.
Anyway, it's all good stuff. I mean, it's tough work, so you got to have a sense of humor. You're dealing with some pretty sensitive issues there too. Anyway, so I've talked to a few of you guys or gals and everything in between, I should say. And I want to ask you a question about that because it seems that the trend, and I even asked someone from Wisconsin this, but prenup agreements. You said there, what'd you say? Getting married with your fingers crossed. I mean, that seems to be a trend, right? Everybody has a prenup agreement.
I always get the question, what's going on trend-wise, right? People are always curious about what's happening in our society. And I have to say, I don't have an adequate representative sample to tell you, what's going on with the institution of marriage. Are more people making families outside versus inside? And I honestly am not going to speculate. All I can tell you is what I see, and this, and the survey sample size that comes to me is always going to be unrepresentative, because most people getting a divorce or having disagreements with their spouse or the parent of their child, most people can actually sort it out themselves. In fact, I think every person in those categories do have disagreements, and they do sort them out themselves. So I only get the ones that not only can't sort it out themselves, but they need to spend money on a lawyer to help them with it. So I honestly, the answer to the question is, I don't know.
Okay. No, the reason why I ask you is because, in all seriousness, I've talked to other, family law attorneys, and they're drafting these agreements before people get married. So not after the fact when they have issues and try to sort them out. So that seems to be like there is, and again, it's just anecdotal. I don't have any stats, but people.
And I should qualify that I do with my fingers crossed thing. It was much more a joke than anything.
No. I get that.
There are plenty of circumstances where that makes a lot of sense, and I support that.
Yeah. It's just, I mean, because I think people were reticent to do that before, but it just seems to be standard now. So it's interesting, but it makes sense to me, right? I mean, it's really, in a lot of ways, not to be too clinical about it, but it is an agreement, right?
Well, it's just like with death. If you die and you don't have a will, the state in which you reside gives you one. Right. If you get a divorce and you don't have a prenup, the state in which you reside gives you one.
Right.
So, do you care to write your own, legal analytical framework by agreement? And for a lot of people, the answer is, yeah, that makes a lot of sense.
Yeah. Okay. So give me like a typical case that you work on. Or if there
honestly, it's funny. Typical. What is typical? Well, I guess the best way to answer that is by telling you the issues that typically come up.
Okay.
So if they were married, obviously terminating marital status is an issue, and that's sometimes can be complicated, especially when we're dealing with the effect that that's going to have on pensions, on tax ramifications, on employer provided benefits, health insurance, et cetera. So marital status is one, if they were married, in fact. Child support is obviously a big issue. Spousal support is a very interesting concept. It's a very old concept, legally speaking, that's being applied into the modern world today, and it's interesting to see how that happens. Child custody, of course, parents disputing about where the children live or decisions pertaining to the children. That's physical and legal custody, respectively. And property, of course, the characterization and division of property. In California, we are a community property state. In fact, all of the states, I believe, all of the states that were formerly Spanish colonies, including California, are adopted the Spanish community property regime. And I have to say that the Spanish were light years ahead of the Anglos out in your neck of the woods on the East Coast, because, back when all you guys on the East Coast thought that women were chattel, we in California, I say we, because I'm not of Spanish descendancy, but we in California recognize that the fruits of a marriage, the assets that are accumulated, are as much the property of the spouse that stays at home and tends to hearth and fire and raises the kids, than the spouse that goes out and brings home the bacon, which I guess for the rancheros was kind of a literal thing. So anyway, so there's property, and then and of course a substantive issue is attorney's fees. Lawyers aren't cheap, especially in hotly litigated or complicated cases. And California has an interesting attorney fee rule. Unlike every other area of civil litigation, in California, we have an egalitarian fee shifting rule. Okay. So if you know what the English rule is the loser pays, both sides lawyers. Okay. The American rule, which is the default in civil litigation, across the land, is each side pays their own fees. Of course, there's many exceptions to this, but that's the general rule. In California family law, we have an egalitarian rule where if one spouse has greater access to funds to retain counsel, we don't want that spouse out lawyering the other spouse. So that spouse is required to contribute to the legal fees of the less well-heeled spouse.
That's very generous.
So I'm sorry to be a politician and answer the question that I wish was asked, but I hope that was sufficient.
Oh, that's okay. I mean, you're entitled to answer it any way you want. This is your show, so I'm just trying to prompt you with questions. I'm curious about it too, because I know it does.
Yeah.
The interesting thing about this country, right, is things, at least today, vary state by state.
Oh yeah. Well, and historically, and with some extremely limited exceptions, family law, domestic relations law, is exclusively a matter that's left to each state to decide for itself.
Got it. And does it get pushed down any further than the state level, or is it just at the state?
I can speak for California authoritatively, and the answer is no. And I'd be surprised if any other states allowed localities, counties, to enact legislation about affecting marital relations.
Got it. I mean, I'm thinking about like some counties in some place where they view the concept of marriage differently than others.
Well, okay, so I have a vague historical memory of a historical thing, which was common law marriage. Okay. Common law marriage was this kind of outgrowth of back in the, imagine the Wild West. Okay. A lot of people living in very rural, very remote areas, and they didn't have access to, the local, it was impossible, in the horse and wagon days, it was it was impractical or difficult for people to go and formalize their marriage, okay, in front of a justice of the peace or whatever. So some of these rural areas, and maybe it was a county thing back then, I don't know, did recognize common law marriage, but then there was a huge backlash against it. I'm talking like late 1800s, I want to say, and they put a stop to it. So people come and when they use the phrase common law marriage, you kind of get a chuckle, because that hasn't been around for over a century.
So that doesn't even exist. It's just that people still use the expression.
I can't speak authoritatively about all jurisdictions, but in general, common law marriage was done away with over a century ago, most of the place, because of social mores at the time, that it actually led to meretricious or socially unacceptable non-marital relations, okay, which we're well past that at this point. And in California, the closest thing we have to common law marriage is what we call Marvin relationships. And not to completely go down a rabbit hole, but you remember Lee Marvin from The Dirty Dozen?
Vaguely.
Yeah, he was a big actor in like the 50s and 60s, and you'd see, if you saw a picture of him, you'd recognize him.
Yeah.
And he had a relationship with a woman, and she sued him on a contract theory. They were not married, they did not have children, and she sued him and said that he made a contract with me. I forget exactly what the terms of the contract was, but I would support him in his career, and he would make sure that I was taken care of financially, something like that. That was our contract, just two consenting adults making an agreement. And Lee Marvin and his high-powered, Beverly Hills lawyers took this issue up to the California Supreme Court, and they said, "Look, our relationship was sexual in nature, okay, among other things, and if she thinks she's going to get paid for that, that's what we call a meretricious relationship. And so, therefore, the contract, even if it did exist as a matter of law is unenforceable because it was in furtherance of a meretricious, meaning immoral contract. It's essentially it's the equivalent in common language of a prostitute suing a John for unpaid fees. Okay, that we all, I think, would agree that claim might be laughed out because that is an illegal contract. So it's the same idea. And you go up to the California Supreme Court, Lee Marvin loses, and the California Supreme Court says, look, that's not a good argument. If two consenting adults have an agreement, and that's an enforceable agreement under California law, then we're going to enforce the agreement, notwithstanding the fact that there's sex involved. And ever since then, from time to time, we get these Marvin claims, and really all they are just contract claims. And the problem with that is proving the terms of the contract. But there are lawyers that will do that, and that's handled. That's actually not technically a family law matter in California because it's a civil contract dispute.
Got it. Interesting. Very interesting. Learn all kinds of things from you guys. Since I'm not a lawyer, play one on TV. Do you litigate? Does your practice? You do. You have to litigate sometimes.
Yeah, I say this to clients so much I put it on the bio in my website. For those people that I mentioned earlier who need my kind of help,
yeah,
and they get escalated to me, this is the standard thing I say in all initial consultations. Okay, just understand my approach to what I do and the tools in my toolbox that I could use to help you in your issue. Okay, you have to understand that our dispute resolution system is binary. There are two ways and only two ways that your case gets resolved. Either you and your significant other have a meeting of the minds, you reach agreements, and the lawyers draw up the agreements, and you sign on the line that is dotted. Okay, that's option one. Option two is the judge decides after a full trial on the merits, which nobody wants. Let's be clear. Okay, nobody wants that. But that's it. Those are the only two options. And corresponding to that, you should imagine that I have two and only two tools in my toolbox. One being the olive branch of settlement. Okay, and we must use that olive branch in settlement, not only because it's the morally right thing to do, but also because under California Family Code 271, I can be sanctioned. My client can be sanctioned if I do not put in serious efforts to trying to settle the case and trying to cooperate with the other side. Okay, that's the counterpoint to the egalitarian fees. And so we have to use the olive branch, but frequently, especially in cases that come to me, the olive branch isn't going to work. And there's a multitude of reasons why the olive branch doesn't work, but it's not. Okay, so let's reach for the sword. Now, nobody wants to reach for the sword, but and the sword is, of course, litigation and moving the case forward to having the judge decide it because we can't. And there's plenty of lawyers that I've seen in my practice who just want to do the olive branch. And in fact, that's a significant percentage, I think, of a lot of lawyers that do family law either as their focus or as one aspect of their practice. And come on, do we really have to litigate this? Do we really have to go to the mat on where the kid goes to school? Why can't you two figure it out? Okay. You can't be a one-tool lawyer. I actually wrote that on our chalkboard in the coffee room today. Essentially, actually, no, what I wrote was the secret to raising children and resolving cases, is the carrot and the stick. You need I said, you need both the carrot and the stick to raise children and to settle cases, and to resolve cases rather.
Right.
So litigation is absolutely what we do. It is never, ever the first choice. But it's the only, it's the only way that I find that I can get good outcomes.
And are those jury trials or
no, in California,
only bench trials?
Bench solely.
Okay, so you don't get to go in front of a jury and have
no, that would terrify me. My peers judging me. At least a judge, like I I kind of know how the judges are wired. We're in front of the same judges frequently. You know, being in front of a jury, I don't know. I really respect the lawyers that do jury trials because they really are putting on a show and they're putting themselves out there.
Right. Oh, really? You'd be afraid of that?
I'm not afraid to say.
Okay, interesting. Yeah, no, I mean, a lot of the attorneys I talk to, it's like, you know, they live for like to get in front of the jury. I mean, you know, as we know, I mean, most don't ever go to a jury trial,
right?
But anyway, interesting. But so that's a different experience, right? I mean, you still have to make your case and argue your case and do all that stuff, but you're not at the mercy of.
I put myself on do not disturb. Excuse me. Yeah. And it's a much slower process. So I've seen a number of jury trials. I tried to get on a jury once, and I got bumped because
Booted,
I was told later by my friend who practiced who's a district attorney, assistant district attorney. The reason why the defense in the criminal trial bumped me was because they didn't want to try the case to a jury of one. Was his best guess, because during voir dire, the judge had to disclose that I had appeared in front of the judge many times, and so that was no secret that I was a lawyer. But yeah, it seems from what I've seen in jury trials I've watched, and of course YouTube has a lot of that stuff on YouTube. It's much slower. Yeah. And you know, we have a little evidentiary problem that comes up. Okay, pause. Gotta excuse the jury. We got to have our argument. We got to do sidebars. You know, it's much judges when it's just a bench trial and the judge is not only calling balls and strikes on the evidentiary issues, but also is the ultimate finder of fact. To some degree, it's streamlined by comparison.
Yeah, I would think so. Much more soon, and you have probably more control over the outcome. I would think too, right?
Judges are extraordinarily independent-minded people. I say this to clients all the time as they approach litigation. Like, I'm going to give you my best guess about this. You know, I've handled cases like yours before, so I can make a very well-educated guess about a range of possible outcomes that I see for this.
Yeah.
But quite frankly, every time I go to court, in some way, I'm surprised about something, and I'm always impressed by how, you know, you've got one lawyer telling one story and asking for this outcome, and another lawyer telling a different story, asking for a different outcome, and then you got the judge who goes his or her own way. So very independent-minded people.
Okay, but so you have a lot of different judges, you're saying, so you don't get used to one. I mean,
that's very fair to say. I mean, Contra Costa County is the focus of my practice, and right now we've got 6 departments, and there's been some staffing issues. But you know, I was at Judges Night last night, which was where the judges sit at a podium, and we all have, and then the bar is. You know, the bar association is there, listening to them speak, and so there were 4 judges on that panel. So yeah,
interesting. So I guess what I'm asking you is because I'm curious, like a jury trial, we have to sort of do focus groups and mock trials and figure out like how things are going to play, et cetera. So you make sure that your argument is compelling as it can be. You don't have to do the same kind of things in front of a judge?
There is no cause for doing focus groups in family law when you have a judge. No.
Okay.
Instead, what we do is I'll go around and I'll speak with all of my colleagues here at the firm about who've also appeared in front of this judge, and we'll spitball and we'll kind of try to prognosticate. Okay, how is this judge going to approach this issue?
Okay, but it wouldn't add any value to just have this independent group give you their opinion.
The only people whose opinions that I care to hear when it comes to predicting the outcome of litigation are people that have had a fair amount of experience litigating in front of this particular judge.
Okay.
And I could tell you that if a layperson non-lawyer fits that bill, that person's got
other
It's
problems.
spent too much time in front of one particular
Yeah,
thing.
I understand. Okay, good. What's like your most memorable case that you worked on? Anything really interesting?
Yeah. And and obviously, I'll preface the question by saying that pursuant to Section 6068E of the California Business and Professions Code, I am required to, and I'm going to quote the statute, I'm required to protect the confidences of my clients at every peril to myself. So, Jonathan, if you were going to torture me right now, I wouldn't give you any specifics as to cases that I've worked on. But I will say more generally that I've had a couple of cases that essentially you could say I represented a parent. I won't mind saying in these cases it tends to be the father, but not always, who has made a mistake, who has sinned, who has transgressed, who's fallen down in one way or another, but generally has done so in a way that doesn't pose a significant threat or a threat at all to the health, safety, and welfare of the children. But that sin, that transgression is received by the other parent, again, not always, but not infrequently the mother, in this lumping of cases, as actually it is a good cause for why the father should not have a meaningful and extended, impactful relationship with the child. And examples of the sin could include infidelity. It could include the kind of infidelity that I was referring to earlier, in case it might get laughed out. Okay. It could include a transgression with respect to the property rights. It could include disturbing the peace of the mother, but not in any way threatening the children. It could include sending harassing or allegedly harassing, it's all the eye of the beholder, emails or text messages, all of which, by the way, in California constitutes domestic violence. And as a result, the father is essentially excluded from the child's life when they come and meet with me for the first time. And I set him down and I say, okay, here's the plan. Here's what we're going to do. We are going to demonstrate to any reasonable person's satisfaction that you do not pose a threat to the health, safety, or welfare of the children. If I can prove that, and that it's not detrimental to the child to be in your custodial care. If I can prove that, and I can figure that out real quick. I mean, is this person somebody who is ordinarily a fine and upstanding member of society who has fallen down for whatever reason, or is this person all around bad news? Okay, and I will only work with the former. And if I'm satisfied that they are, then the tools in my toolbox are I will be able to demonstrate to the judge absolutely that you are not a threat to the child. And what that means is in California law, if I prove that, then this policy of the state is to ensure that children have frequent and continuing contact with both parents after their parents' relationship is ended, because we know developmentally from a significant amount of social science research on this, that from a developmental perspective, children who have frequent and continuing contact with both parents throughout their childhood have better outcomes, developmentally speaking, than children who don't. Okay, we're talking about college passage rate and likelihood that they'll be convicted of a felony and propensity for drug and alcohol use, et cetera, et cetera. So in a nutshell, one of the cases that bring me significant amounts of satisfaction are the ones where I can use tools in my toolbox to overcome unreasonable or inappropriate objections by one parent that puts up barriers or walls between a good parent who's made mistakes and the children. And I actually have a phrase for this kind of, it's a narrative, right? It's the redemption narrative. Okay, made a mistake, you've fallen down, and it's time to be redeemed. And I tell you what, Everybody loves the redemption narrative.
They
You
like
look at
that.
you look at films, you look at music, you look at world religion, and they're all kind of the
Redemption
best stories are all the redemptive
Yeah,
stories.
that's right.
Because we're all sinners at the end of the day.
Right. That's interesting. That's a good way to sort of frame it. Yeah. If but what you have to determine, right, is are they worthy of that redemption?
Well, what I have to
Right?
determine
That's the
is,
Pascal.
will I work with them? That's fundamentally what I have to determine. And I won't tell the redemption narrative unless I believe in it. So, I mean, that segues to something I say to clients all the time, especially clients that are going to litigation with me. And it's this. You have to understand what I do for a living. I am, and this is not original with me, Posner Dobb is where I heard this for the first time. I am a competitive storyteller. On one set of evidence, I tell one story to the judge. And on exactly the same set of evidence, my opposing counsel tells a completely different story.
Right.
And the story that sells is the story that wins. The lawyer who sells the story is the lawyer that wins. As I said, it's caveated because judges, it's actually more of a spectrum than binary. Okay, do they more fall on my side of the view or their side of the view? But whatever, it's the same. It's the idea. And so you have to understand that I'm a professional storyteller, a competitive storyteller. And here's the secret. This is a Gary Spence notion. You cannot tell a story, win, if you don't believe in it, honestly, sincerely, truthfully. Okay.
True.
And and here's the thing, I'm in a line of work where people are very quick to call me a liar. Okay. And the way that I conduct my practice with that in mind is, to the greatest possible extent, I'm a servant to the truth. Okay. The objective truth. Because at the end of the day, all I have to sell is my credibility. Okay. And in family law, you'll find, especially in the most frequent form of family law litigation, which is law in motion. Okay. If you know what that is. Frequently what it looks like is the lawyers are testifying. The lawyers are just spewing facts to the judge, and then they're interweaving argument into the facts. And really what they're doing, and I make a point of this, is I say, Your Honor, as an offer of proof, I say, blah, 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 which is essentially me saying, I'm not the one testifying right now, but here's what I believe that the evidence will show if we were to have a trial and you were to receive admissible evidence, which what I say is not. Okay. And I work assiduously, because this is all I do for a living, to protect my credibility, and that the judges know that what I say they can take to the bank.
Interesting. So you mentioned Jerry Spence. Have you attended his college?
I have not. I've listened to his audiobook.
Ah, interesting. But that's, I mean, the guys that go there, and I was just in LA for a few days at Trial Lawyers University last week. I mean, those are lawyers, but they go to jury trials.
Yeah.
So, but that's still relevant for you. That's why I was curious. Like, do you have to make those same kind of, persuade even though it's one, but you still got to, do you have to sort of test your argument to see how it's going to play?
Yeah. No, this is, the answer to your question is absolutely yes. This is the art of persuasion. It's just persuading judges,
right,
as opposed to laypersons. So there's a big difference. And judges are, especially in the family law bench, they've seen it all before,
Yeah.
And in terms of what I think you're getting at, preparation is everything.
Yeah. Case
Yeah. Preparation is everything. Everybody has their own way of preparing. And a big part of it is surveying my colleagues and testing ideas on them. So in that sense, yeah, I have a lot in common with jury trial litigators. Not that I'm putting on the trial before the trial in front of, a test group that I got off of Craigslist, I'm running it through with my colleagues, and I'm rehearsing in the shower at home. I'm typing out my talking points, that's how I do it.
Got it. Very good. No, interesting. Well, listen, just to wrap it up here, what do you want people to know about you and your firm, and what's the best way to connect with you?
Yeah.
Other than the obvious, your website.
Yeah. That's a very good question. It deserves some thought. Well, I'll take the easy part first. Yes, the website is www.disso.com. That's DISSO.
Yep.
As in dissolution of marriage.
That's what that's for.
That's what that's from.
Ah.
Dissolution of marriage.
Okay.
We got the web domain there. In terms of what I want people to know about me, if you have a need for my services, you want somebody who is absolutely faithful to the truth, that can bring both the sword and the olive branch, and we got to use both. We'll try the olive branch before we get to the sword, for sure. Okay, unless it's kind of far gone, and sometimes it is. You have an adequate amount of humility to listen to me give it to you straight. And I'm going to give it to you straight. And I'm going to call sin by its name, because at the end of the day, people ask me, what is the cause of divorce, do you think? And I have one word answer. It's sin. I don't mean to be religious or preaching or anything like that. And I think you can look at it even in a secular sense. But in all of my cases, I see one or more of the 7 deadly ones. We're going to identify what the problem is. That's step 1. And then I'm going to come up with a plan to resolve it. And the ultimate benefit that you're going to get with me is you're going to get closure, and you're going to be able to find a new mode of existence, a new way of living that at the end of the day might have been better than what you're coming out of.
Excellent. It's a good way to close it. Okay, good. Thank you for that. All right. Well, listen, for everybody, this is Scott Lantry, family law, not matrimonial law. And the firm is Whiting, Ross, Abel, and Campbell in the San Francisco or the Bay Area?
The San Francisco Bay Area. I'll claim Walnut Creek, California.
Walnut Creek, California. And this is sponsored by EmotionTrac, which is why I was asking some of the questions. We are a legal tech platform that helps litigators prepare for mediation and trial. We have this platform where you can tell your story if you're a storyteller, and you can see how people feel about it. We capture emotions and also unbiased feedback through questions as well through the platform. So anyway, thanks again, Scott. It was great.
Right on, Jonathan. I'll be sure to tell my friends and colleagues at the Personal Injury Bar about your excellent product.
Thank you.
Right on.